Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, let's go to, we're going to go to the Ninth Circuit to Seattle. This is really, interesting as well. So here, this is related all to the George Floyd riots, just to put people in context here. There was the mother sues. She's suing because her 19-year-old special needs child, right? Not a child, but he was shot and killed and I'm going to describe where he was shot and killed, but he was shot and killed in 2020. And just to put it in context, the what she's alleging is I was deprived of my son's life. And as a result of the government's failure to take proper action or their deliberate indifference, they deprived me of my son's life. So the court doesn't have a problem with that legally. So let me talk about the facts. Basically, the facts are after the George Floyd riot, the rioters took over an area of the city and they form, I don't know what it stands for, but a chop zone.
Yeah, they call it chop. I forget also, but
yeah, I don't know
sure
what it
there's
is.
some name for it, but
they basically said, and I'm shocked the city allowed it, but they basically said there's no government here. In this zone, there's no city government, right? So the rioters, which, I'm going to regret saying this, but I feel like they say they got what they asked for. They want no government services. They should have gotten no government services, but that's not totally what happened. So in any event, and they had some rules in this chop zone, right? No guns are allowed. These are supposed to be peaceful protests. So this woman's son, special needs man, goes down there, has a negative engagement with somebody. That person then shoots him and they move him to a special needs or to a medical tent. Outside the tent, the city, about 15 minutes away or so, placed an ambulance. But outside this zone, they placed an ambulance. So the city wasn't ignoring what was going on. The people call for an ambulance. There's some miscommunication about exactly where the patient was. And so after 15 minutes or so, I think they just throw him in a truck, take him to the hospital, and he's pronounced dead. So she sues saying, listen, you were deliberately indifferent to the needs of my son and those people in the chop zone. And the court comes out and says, listen, and it really slams the city. So much so when you read the decision, you think the city's going to lose. They said the city, allowed a dangerous condition to take place and really lambaste the city, but says, however, as to the 1983 claim for deprivation of life and property, right, the son, there was no deliberate indifference because there was a miscommunication. And they also said, listen, they were almost going to the public duty doctrine, special duty doctrine, where they said there's no duty really owed to that individual. They may have been deliberately indifferent or unintentionally negligent, whatever, to everybody there, but they didn't owe him a special duty. They didn't really go to that, but that's right where they were. And they, he really slams the city in his decision, but then says, we're not finding against you because we just don't think your conduct what rose to the level. He says your conduct was egregious, but it didn't rise to the level necessary to establish a 1983 claim. So that's really what it is. The facts are more interesting than the law, I think, on this.
I think so too. I've been following this case since it was filed, and I thought it would raise some interesting issues. But here the firefighters wanted to respond. They checked with the police, and what we call, I know in Providence we call it staging. You're staging for the police. By your policies, you're not permitted to go in unless you have some sort of security escort to go into a relatively unsafe area. So they were staged. They wanted to go in, and they did in fact go in, except by the time they got in there, he had already been transported, with a civilian vehicle. But I really like the fact that the Ninth Circuit added that, and I have it boldfaced there, but I'll quote the Ninth Circuit. It is at the ballot box that Sinclair, and that's the mom, and other Seattleites must hold the city accountable for their deliberately indifferent action. So they are saying that there was deliberate indifference. It's just that the medics were not deliberately indifferent.
Right.
The city may have been deliberately indifferent, but it wasn't the city's deliberate indifference that was the proximate cause of the shooting. That there wasn't enough of a connection. So there's really two allegations here. One was that the Seattle Fire Department was deliberately indifferent by having the staging policy, and the court disposed of that. The other was that the city was deliberately indifferent for allowing the chop zone to be created. The court kind of said, you know, you've got a point there, but that wasn't the proximate cause, wasn't really what led to the death of the young man.
Right. And I'm impressed with this because one of my frequent criticism of judges and courts is that they allow the facts to drive the law. And that shouldn't ever be that. Here, right, the facts, they said it's egregious. So normally I would see a court saying, I don't care what the law is. The fact that it's egregious, I'm going to create some law or ignore the law. And that's not uncommon. Here, I like the fact that they stuck to the law and said, I'm sorry, you just don't meet the requirements of a 1983 action, despite the fact that the facts are egregious. That is not overly common, maybe more common for the federal appeals courts, but not overly common for judges. I normally find judges' emotions lead the way.
Yeah, I think judges are intellectuals that find ways to rationalize a case coming out the way they have predetermined that it needs to come out.
Yeah,
that's just
I apologize to all the judges we're insulting, but then don't do it.
I know, but
Prove
I think they use that brilliant intellect sometimes to rationalize an emotional decision that they've sort of prejudged on. So
right.